and others, and the Chancellor of the Exchequer and others.
Good morning, Mr. Quintavalle.
Good morning, my lords, my lady. We're on to the final ground, which is proportionality, which to a certain extent has been covered I deliberately dealt with proportionality issues which related or which arose out of the other grounds. We've made reasonably full submissions in the skeleton, and so these are general observations which go to supplement what's already been said and what's already been written. Proportionality arises if a justifiable interference, one that can be justified, is established with regards to either Article 1 or 2 of the first protocol, or with Article 14 in relation to either of these articles. We say there's no proportionality to consider if we make out our case, our primary case, under grounds 2 or 4, which are the legitimate aim grounds for Articles 1 and Articles 2 respectively, or if the court agrees with our primary submission under ground 6, that in the face of a universal European consensus, the United Kingdom doesn't have a market of appreciation when it comes to deciding whether it's necessary to tax education. If, contrary to what I submitted yesterday, the state does have a margin of appreciation, this margin, we say, is substantially narrowed for the reasons that we've outlined in our other grounds. And the case does involve interference with Article 2, Protocol 1 rights, which are separate, but they're intertwined with the Article 1, Protocol 1 rights. Article 14 adds an additional dimension to the case, and it means that we can, even if, for example, we haven't established that there is a property right under Article 1 of the first protocol, but nonetheless the matter falls within the ambit, and we say clearly does, then we do get to Article 14. And similarly, if the divisional court, contrary to our submissions, and the government's correct, that Article 2 doesn't include a right of access to private schools, and we say that Article 2 does include a right that applies equally to private and state-funded, state-provided schools. Nonetheless, it falls within the ambit of the rights of Article 2, and so we get to Article 14 as well. There is a difference. It's not that we're going to see that matters of discrimination or inequality of treatment do fall to be considered under the substantive right too. So there is an overlap, but there is a difference. It's not that it's the same approach. And what we say, and we relied on Buberina, paragraph 73, is that in cases where the substantive right is interfered with, then discrimination is not allowed. Whereas under Article 14, the discrimination or the discriminatory treatment falls for a proportionality assessment. Now, the courts will always leave a bit of these hard and fast rules are not perhaps very attractive, but what the Strasbourg court has said is that if there's discrimination in relation to a substantive right, then it will need very weighty reasons to explain why this approach has been adopted. And we say that isn't the standard proportionality analysis. We don't go through a bank mallet.
Give me
stage 3 to stage 4.
My phone went off. Didn't have it on silent. We need weighty reasons, and we don't engage in balance. And in terms of the overlap, when it comes to matters of inequality of treatment, disparity of treatment, I'd like to take the court to. So first to say, in Buberina, paragraphs 99 and 100, I don't need to take the court to them, but what the court there said is we found a violation of Article 14 in conjunction with Article 1, so it's unnecessary to consider the complaint under Article 1 alone. In NKM, it went the other way, and I would take the court to this paragraph. It's important to illustrate the the approach that the court adopts. And this is at page 1733, paragraph 84, tab 55. I don't know if tabs are useful, but
So 1744?
1733, paragraph 84. So that NKM was the case of the civil servant who had a higher tax rate than other people, and challenged that. And the challenge was under Article 14 and also under Article A1, P1 taken alone. And the court said, in the circumstances of the present case, the court is of the view that the inequality of treatment of which the applicant claimed to be a victim has been sufficiently taken into account in the above assessment that has led to the finding of a violation of Article 1 of Protocol 1 taken separately. Accordingly, it finds while this complaint is also admissible, there's no cause for separate examination of the same facts from the standpoint of Article 14 of the Convention. So we say we don't, there is a discrimination. On our primary case, it's the interference with Articles 1, Articles 2. They're clearly engaged. We don't need to go into the ambit test. And so we can consider this without getting to Article 14. And it's stricter analysis where the actual right is interfered with rather than some peripheral consideration within the ambit of the Convention. The government has not offered weighty reasons, we say, to justify either why there is a discriminatory treatment or which would allow them to succeed on the proportionality test in justifying the measure otherwise. If we look at the Treasury's technical note on applying VAT to private school fees, which is at page 331 of the core bundle, we can see that the government relies on 4 principles. These are the principles which they say underpin the legislation, and they've been ones which have been invoked by the government.
So is this supplementary bundle 1 brackets core?
I think it is.
I think so.
Yeah.
I apologise if I've given the wrong
Not
reference.
core.
No, that's fine. I just wanted to make sure I had the right page.
So the 4 principles are to raise revenue to support the public finances and help deliver the government's commitments relating to education and young people. B, ensure high quality education is available for every child. C, to be fair with all users of private schools paying their fair share, whilst ensuring that pupils with the most acute needs are not impacted. D, minimise administrative burdens and prevent abuse. And in short, our responses are that mere raising of taxes is not a weighty reason, particularly when this can be done in a non-discriminatory way. And we've made the point before, but I repeat it now, that it's simply no answer to say, well, we need to raise money, because otherwise the requirement of proportionality would always be met in a tax measure. So that just simply isn't a sufficient reason, and certainly not a weighty one. In terms of ensuring high quality education available for every child, we say there's no nexus between private education and state education, which renders it necessary to limit the rights of the former to help the rights of the latter, who are not in conflict. With regards to C, there's nothing fair about discrimination. And so this is not a weighty reason. And as far as D is concerned, we say the administrative burdens are overstated. Tax legislation frequently has to make detailed exceptions, and this shouldn't be any different. We've seen the government acknowledges that this will have an impact on smaller low-cost schools, and
that middle-income families are likely to be severely impacted, and people who can't, for religious reasons, accept a state education will clearly also be particularly impacted. But those are not the category of people for which any concern was had, because we've seen, they've said that pupils with the most needs are not going to be impacted. This was part of their fairness ground, but they haven't considered at all the fairness of the pupils, such as the claimants in this appeal, who have different reasons, not related to disability, which necessitate them having access to a particular form of education. We've seen that the VAT measure takes no account of the income or wealth of the taxpayer, and it's a regressive tax in this respect. We refer the court, I haven't got time to take the court to the witness statement of Graham Leach, which is in the supplementary reference bundle, tab 12. Paragraph 80, on page 84, 6.4, he explains why it's a regressive tax, but it's a useful witness statement which also puts together, notes the various reports which have been conducted, which cast doubt on whether this measure is going to raise any money for all sorts of different reasons. It's not pretending to make any, it's not pretending to provide any opinion as to whether this measure will or will not raise money, but it's highlighting various reports which have been published and which show that, which cast doubt. We made reference to one of them. We saw in the case of Julian and Nalbant and Unison, which is cited in our skeleton, and also Guberina, that measures which do not consider the individual's ability to pay will be disproportionate for that reason. And I would also like to refer the court to the case of Hurst. This is the prisoner voting case, which is in the authorities bundle, tab 47, page 1392, paragraph 82 is where I want to take the court to, and the final line there of that paragraph says, such a general, automatic and indiscriminate restriction on a vitally important convention right must be seen as falling outside any acceptable margin of appreciation, however wide that margin might be. And we say that we've seen what the court has had to say in Shaheen about how vitally important this right is as well, the right to education, and the right of parents to access that education as they wish. So this applies equally to Article 3. If it is permissible to tax education, we say it isn't, then it was open to Parliament to devise a tax which minimised or removed interference with rights and which was in any event far less intrusive. And I just conclude with, it's obviously not the function of the court to say this is what the government should have done, but there were options available. The first was to charge wealthy parents, perhaps higher rate taxpayers, who choose to send their children to state schools, a fee to cover or partially cover the cost of the education of their child. The second way was to put in place an exemption from VAT, or for the state to pay or have a rebate system for those parents who could not afford to pay VAT, but required to send their children to particular schools for religious reasons. And the government, we've seen in the evidence which the Claim 1 claimants have put in, that the government has implemented this with respect to military families and dance and music academies. So it's not that it's impossible to have a rebate scheme. And this is the approach suggested in the cases of Unison, Julian, and Nalbant as well. The other possibility is to give discretion to the Secretary of State to consider individual applications, and this was what was done in Begbie, and we submit that's why that case was convention compliant, and why the legislation in that case was convention compliant, and why it isn't in this case. The other way was to finance education from general taxation, so that it was certain that only those who could pay would do so, and we saw that this is the approach that the European Court of Human Rights endorsed in NKN. And finally is an exemption, and what's been suggested is for schools charging less than what it costs the state to educate students. And that's the position, one of the positions advanced by the Claim 1 claimants. And if our claims on principle don't succeed, we would certainly join ourselves to that request. We say that it's this bright line rule, if a bright line rule is needed, it's justified. Because a parent who is prepared to forego free education, but only to pay less than what would have cost the state to educate that child, must have good reasons for wanting such an education. My lords, my lady, those are submissions.
Thank you very much, Mr. Quintivani. Sir James.
Lords, my lady, we're going to split the advocacy. My learned friend Miss Hannes is going to be dealing with a number of points, particularly focused on the justification arguments in relation to evangelical Christians, in other words, Mr. Quintivani's clients. I'm going to deal with most of the rest. That's acceptable. I was going to start with A2P1, Article 2, Protocol 1. So far as this court is concerned, that appeal is only being pursued by Mr. Quintivani's clients. The C1 claimants, Mr. Broach's clients, who led the charge below under the guidance of Lord Panic in relation to Article 2, Protocol 1, are no longer pursuing those issues. They restrict their appeal to the Article 14 issues, which I'm going to come to at the end. But I start with Article 2, Protocol 1, because it's the logical place to start, given that the appeal is live in relation to Mr. Quintivani's clients, but only those clients. And I start with the nature of the right, or the rights, in Article 2 of Protocol 1. And we're particularly focused on the first sentence, which provides that no person shall be denied, that's the formulation of the right, no person shall be denied the right to education. Well, obviously some of the case law deals with the second sentence as well, which is the content of what the state must provide, as it were, what it can't do when providing that education. Our submission is that the case law of relevance, and there was quite a lot of it was gone through below in some considerable detail, is helpfully summarised, and no one seems to have quibbled with this, at paragraphs 30 to 53 of the Divisional Court's judgment. I wanted to pick out 4 principles that emerged from that. You'll remember the structure of the judgment, a summary of the case law between those paragraphs, and then a drawing out of the key themes from the case law, which I'll come back to in the Divisional Court's judgment. But just so far as the key principles that emerge from that case law is concerned, can I identify 4? First, as I've already to some extent flagged, the right is in nature a right not to be denied education, which, with all that formulation of the right entails. Secondly, the case law confirms that the state is not required to provide funding or subsidisation or social assistance to enable people to send their children to private schools. The core principle of importance was set out by the Grand Chamber of the European Court of Human Rights in Belgian linguistics. You have that case, if you want it, in the authorities bundle at tab 38, page 1155 is the start of it. I wanted just to go to that very briefly. And if you're operating all electronically, if you go to 1183, you'll see at the bottom of 1183, the last line, the negative formulation indicates. If I can invite you to read that paragraph and the one that follows it. sets the scene, as it were, then you go, if you go to numbered paragraph 4 towards the bottom of 1184,
Yeah.
yeah. And then I think from those paragraphs one can go back to the divisional court's judgment, if we may, if you have that separately.
Paragraph.
It's paragraphs 30 and 31, which deal with Belgian linguistics. You'll see in 31 in particular, the court held A2P1 does not impose specific obligations concerning the extent of those means or the manner, their organisation, subsidisation, and so on. So it's really the guarantees of a right of access to educational institutions existing at a given time, and no obligation to establish at their own expense or to subsidise education of any particular type or at any particular level. That's what you got from 1183 to 1184, that passage in Belgian linguistics. That was cited with approval in this context by Lord Justice Peter Gibson in the Begbie case, and that is dealt with in the section dealing with domestic case law, particularly at paragraph 48 of the judgment. I just invite you to cast an eye down the quote from Lord Justice Peter Gibson's judgment in Begbie in paragraph 48 of our divisional court judgment. So there are perhaps two things of importance emerging from that quote. The first, the protocol proceeds from the premise that each state possesses a state system of education, and Article 2, Protocol 1 was designed to ensure that access to that system was not denied, and there's no obligation under A2P1 to continue to provide the funding for a child to go to private school, where education is available in the state school at public expense. That was the proposition he'd described as startling at the beginning of that quote. And that Belgian linguistics principle has been confirmed in a number of the Strasbourg cases reviewed by the divisional court. So if one takes, by way of example, go back to paragraph 38 of the divisional court's judgment and remind yourselves of the facts of Simpson and the finding of Simpson in the United Kingdom at paragraph 38. Case about a mother struggling to pay private school fees for the special school that was needed for the child. Similarly, if you go back a couple of paragraphs to WNKL and Sweden at paragraph 36 of the divisional court's judgment, again not providing assistance there to a Rudolf Steiner school to enable it to buy textbook and other educational aids, declared inadmissible. X and the UK, going back again to X and the UK at paragraph 34 of the Divisional Court's judgment. Applying the Belgian linguistic principle, and just so you note it, the Campbell and Cousins case on which my learned friend Mr. Quintavardi placed some reliance yesterday is considered at 35 of the Divisional Court's judgment. And we submit thirdly that this is all of a piece with the other case law indicating the limited nature of the right. So it doesn't cover or guarantee a right to any pupil to attend any particular school. One gets that from the Lord Grey judgment, Lord Bingham's judgment in the Lord Grey case. That was the passage that the Divisional Court judgment quotes at paragraph 49, just at the top of page 173 in the bundles. Just remind yourself of that quotation from Lord Grey. And you see the references to similar reasoning from Lord Hoffman in the same case at 56 to 57 in paragraph 50 of the Divisional Court's judgment. It may be worth just showing you those paragraphs in the raw, as it were. We sent this morning, I think, a copy of the Lord Grey case in case it would be helpful. I hope you should have that electronically.
Yeah.
Could I just invite you to go to paragraphs 56 and 57 of Lord Hoffman, which are cited but not fully cited by the Divisional Court, and ask you just to read 56 and 57 in their totality. That same flexibility and the breadth of the obligation, the discretion on the state inherent in it, one also sees from the citations from Tigieri in the Divisional Court's judgment at 52. If you flick to 52 of the Divisional Court's judgment, you'll see in particular the quote from Lord Hughes. You'll remember that the court was there split as to the result. I think it was 3-2 split on the result, but as they've taken that into account, I just invite you to remind yourselves of the Lord Hughes' important qualification, as it's put by the Divisional Court.
Sorry, what's the point you're deriving from that? That's a case about tertiary education.
A case about tertiary education.
And the state has no obligation to have any tertiary education at all. So what's the point?
I mean, it's simply the flexibility of the obligation that is within Article 2 of Protocol 1. It's really leading up to the themes that the Divisional Court below drew from this line of case law, both domestic and convention. I'm not seeking to apply these cases directly to us. Some of them are more applicable and more obviously of interest than others. Those cases where, for example, the Strasbourg court says, well, if you're compelled to go to state school, even if you have a particular religious belief, you're still getting an education. Some of them are more close to our facts or the relevant parts of the facts that remain than others. But I show you these to illustrate the breadth of the principle and the discretion that is afforded to the state under the nature of the right that we're dealing with, which is A2P1 for present purposes.
And you're dealing with the first sentence of A2.
We're dealing principally with the first sentence of A2P1, the right not to be denied education, to which these points really chime. The state's education system exists, as it were, to cover everyone. It's a point I'll come back to. My fourth submission really draws on and leads into the themes that the Divisional Court drew from this case law, and it's in effect that the state can make and remake policy in terms of the way in which education is provided. And that implies a freedom to make and remake policy in relation to the rules, including the tax rules, applicable to the private sector. But we submit more generally that the Divisional Court at paragraphs 54 to 58 in particular were entirely correct to identify the themes that they do from that case law. So they, in essence, they acknowledge, as you would have seen from these paragraphs of the judgment, they acknowledge the importance of the right to education for obvious reasons. But they note in paragraph 56 that the Strasbourg court has navigated what they describe as the difficult waters, and they're particularly difficult when you're dealing with the sorts of balances that have to be struck, but they allow the states a broad margin, as one sees at paragraph 56. And they also correctly identify in 57, the second of the themes, the level of policy choice that is inherent in setting up a state's education system in all its aspects, and the various different ways in which the Council of Europe states do that. And they tie that back to the basic Belgian linguistics principle, as one sees at the top of page 176, halfway through paragraph 57. They tie it back to that, and that explains, that they consider we submit correctly, why it is that Strasbourg have produced the principle that they have and stuck to the principle they have in Belgian linguistic and following cases, reaffirmed as we saw in Lord Grey and other cases. And it also explains why the position is as it is in paragraph 58 of the judgment. If you stand back from it, the basic theme is lots of policy choices, lots of breadth of margin for obvious reasons accordingly. Children can't be excluded so as to be, in effect, denied a right to education. That's the formulation of that first sentence right. But how the education is provided is a matter for the state, with all of the policy choices that are inherent in that. That applies from the curriculum to the basic ways in which education is made available to all children. And as part of that approach and principle, no obligation to subsidise or provide funding or provision of favourable tax treatment as a mechanism of state funding any particular sector. And that leads to the fifth and final point, which is that the state will deny a right to education only where the effect of the thing complained about is such as to impair the very essence of the right. So the limitation in question must be of such severity as to shut down the possibility of education for the child.
So at this stage of the article, you're saying the law is not concerned with the quality of the education or the type of education, for example, that it should be religious instruction according to the parents' religious beliefs.
Yeah.
But, well, wait, Sir James, you say preference. Actually,
Right, I'm only mirroring the language in 149, which we'll come to.
Yes, right. But
strong cultural or religious preference.
But the appellant, whether their legal grounds are successful or not, the appellants to these appeals, I think, would say that they're not merely expressing a preference, but they have profound religious convictions which lead them to the views that they hold about, for example, how their children should be educated.
My Lord, I wouldn't seek to deny any of that, of course.
No.
The question is how that sits within the scheme of the...
Right. But I think the case law and the threads of principle you've shown us so far are about the first sentence of A2P1. And you're going to come on to how this all works in the context of the second sentence.
Oh, yes, but I'm dealing with the first sentence as well from this perspective, because there may be a variety of ways in which the state provides education, and there certainly have been some cases in Strasbourg, I'll come back to them, but there certainly have been some cases in Strasbourg where, for example, there was compulsory education, I think in Germany, in the state sector, and a set of parents objected to that on the basis that it didn't properly respect their religious and cultural...
Yes.
I use preferences neutrally, positively accepting the point and all put to it, the strength of the feeling and so on. But it does tie into the way in which they've approached that first sentence and the flexibility and the policy choices that are inherent in that and what impairs the very essence of the right actually means, and whether you can insist on a particular manner and form of education or the subsidisation, to use that phrase neutrally, but the subsidisation of a particular way of providing that based on religious or philosophical or other strong convictions in the parents. That does go to the denial of the right to education, the strictness of that concept, the narrowness of it, particularly having regard, in relation to the first sentence as well as the second, to the breadth of the margin that the state is afforded, the fact that it can make and remake policy, and so on. It's the availability of the education provision that is key. So that's how we put it on that side of things. As I say, none of those basic themes is really taken to task. The Divisional Court aren't taken to task by Mr. Quinterval in relation to any of that basic analysis in relation to the nature of the rights in Article 2 of Protocol 1. What he seeks to do is to broaden that out, to broaden the right in Article 2, Protocol 1 out. And he does so, firstly, I'm going to pick up the two basic points that he makes on the appeal. The first of them is that the international instruments which he relied upon, he says, were not properly considered by the Divisional Court, and what they lead to is a broader right. In effect, he has to assert it's a broader right that encompasses not imposing VAT on school fees. So encompasses, he says, an obligation not to impose a tax or indeed take any other step, I think is as broad as he put it, that would hinder the pursuit of the parent's choice of school for their child based on religious or philosophical conviction. He puts it that broadly on the basis of the international instruments. And our answer to that case based on those other international human rights instruments, you'll remember the ones, the United Nations Convention on the Rights of the Child and so on, is firstly that he's wrong to contend that the Divisional Court did not consider those. They did. If you go to paragraphs 96 to 98, of the Divisional Court's judgment, page 184, you'll see that they considered specifically all of the obligations that he sought to rely upon and all of the international instruments that he sought to rely upon for his broader right. And they concluded, we respectfully submit correctly, that they didn't take matters anything further because they didn't have anything relevant to say about the question whether the contracting parties may impose VAT on school fees. That's the conclusion in paragraph 98. And my learned friend's submission simply comprised a bunch of assertions about what those provisions imported, and that they went as far as to tell you that the state couldn't impose VAT on school fees without seeking to address that reasoning. And we respectfully submit that the divisional court's reasoning is obviously correct. There's nothing in the rights in those other international instruments relied upon that tells you anything about any form of specific obligation not to impose VAT on school fees or not to do anything which might hinder a parent's choice or preference about which school their child goes to in the way that the state is in effect obliged to subsidise that. And we do respectfully make the submission anyway that to the extent that those international instruments might be relevant to the scope of the rights under A2P1, we've seen at least one case in which the Strasbourg court referred to them, they're already built into the case law. So to the extent that Demir and Turkey allows one to take into account those international instruments for the purpose of interpreting the convention, that's already been done. It's already factored into the Strasbourg case law that the divisional court analysed in the passages I took you to earlier. That's the first submission, therefore. The second submission is that in any event, on the face of it, the language in those international instruments is simply too general. This seems to be close to the heart of the divisional court's reasoning, simply too general to assist in the identification of the sort of principle which my learned friend Mr. Quintavalle would need, still less something as specific as imposing an obligation not to charge VAT on school fees. And we do note in that respect, in relation to the generality of the language and the nature of the obligations, even ex facie, in those international instruments, that they are obligations that are in effect imposed at a state level. That's the level of generality at which they operate. And so that would obviously include, if I can put it this way, in very general terms, advancing the lot of the 94% of pupils who go to state schools. These are general, to some extent, aspirational obligations that are imposed on states, but they're imposed at that state level. What my learned friend needs is a principle of considerable specificity. You can't impose an obligation, you can't impose VAT on school fees, you get nowhere close to that. So what he seeks to do is to say, well, they don't do that, but they support some broader obligation not to do anything which would hinder a parent's choice. But we know that's not the approach to A2P1 in Strasbourg, from the case law that was identified by the divisional court in the paragraphs we went to earlier.
Well, can we just pause there?
Yeah.
Leaving us, suppose you're right about the scope of the international instruments and so on. Can we just address this at the level of principle and analysis? I suppose you would say that even before this VAT change was made, there have always been some families in this country who do have a religious conviction, which in principle means that they ought to be going to a private school which conforms with their religious convictions, but they can't afford it. On any view, even if you have low fees, they just can't afford it. And you would say that's not a breach of A2P1. Is that right?
That's right.
Secondly, you say the state is not, because they can't afford it, the state is not required to give them some kind of subsidy to afford it.
Yeah.
So far, so I understand. But the third stage is, I think Mr. Quintavalle argues, finds, so far as the legal analysis goes so far, no right to a subsidy. But if a parent can just about afford it now, pre-VAT change, what the state can't do lawfully, he says, is impede that ability by sticking a tax on that.
That's what I'm going to come to.
And he says that's not a subsidy.
Yeah.
He's not asking for a subsidy. He's asking for you to refrain from doing something you haven't done before.
Yes, but he says it's not a subsidy, but that's to some extent that's casuistry. I mean, the answer is that it's the state staying its hand to tax in a way that it otherwise taxes services. But I'm going to cut.
Doesn't that, James, depend on the starting point? and Mr. Quintavalli would say education has never been taxed in that way.
Well, it may never have been taxed in that way, but some of the services are already subject to tax regime, to the imposition of the tax regime. He accepts that the tax regime could be altered so as to increase, as it were, the cost that a school would have to face or pass on to parents, and that wouldn't be objectionable. So it does become quite a narrow distinction if you say the only thing they can't do is put VAT on the school fees in a way that they haven't in the past through the creation of an exemption. I do respectfully submit, I'm going to come to this in relation to the essence of the right arguments, because the Divisional Court specifically addressed this argument, but I do respectfully submit that when the Belgian linguistic case refers to funding or subsidisation, it's not using those things as terms of art. It's referring to what the state doesn't have to do. The state doesn't have to assist. And the corollary of that is that the state can impose taxes. It's not just don't have to provide funding. I mean, the exemption on VAT on school fees that previously existed was a way of providing more favourable treatment to private schools. And they're not using that language in a technical sense or in a term of art sense. But on the international instruments, which is the only point I'm really on now, I'll come and show you the paragraphs in the Divisional Court's judgment where they deal with the essence of the right, where these points are more directly addressed. But on the international instruments, the point is that none of them come close to suggesting that that would be a precluded thing, or that there is an obligation on the state.
If that's right,
not to do that.
if that's right, would there be anything to prevent the state from imposing a level of VAT on school fees which is higher than the VAT charge normally imposed on goods and services in this country?
Well, my Lord, my respectful submission is that there would be no difficulty with that in principle.
Yeah.
I mean, it may depend on the precise level, because as we know from the debate we had last time, it's a point decided that the Divisional Court decided that you've seen that private schools can continue to exist, they can be part of a panoply. So you might bump into that at some point, depending upon the level. But beyond that, if it goes 1% over, it's 1% more, 2% more, 5% more, 10%.
But if they decided that they don't really like private schools, but they're not going to abolish them, but they're going to impose a 90% VAT charge on it.
Well, then you may get into different proportionality arguments at that stage, because that might be held to impair the very essence of the right and so on. If you get into that debate, we know that that's the principle. You can't impair the very essence of the right. The question is how that works.
But it might be said that's no longer, even on your analysis, that's not a subsidy. Because you've said that really this is casuistry to say this is not a subsidy. But I think Mr. Quintavalli would say that actually for his clients, or at least some of them, it is effectively like imposing a 90% VAT charge because they can't afford it.
Well, my Lord, again, there may be questions of degree involved, but this is to regularise, as it were, across the VAT system, the charge that applies to services.
Well, that's never been said to be a justification. We've got 4 justifications. We've got a lot of evidence about it. Nobody's ever suggested this is regularisation of a charge for services. So that's just new.
Well, my Lord, we don't need to run that as a separate strand of justification. I'm trying to answer my Lord's question. That's what has been done. I'm addressing the question, if it was 90%, can you truly describe this as a subsidisation?
Can I just ask again, the test of impairing the very essence of the right, in my Lord's example, even at 20%, some of these appellants would say you've done just that because they can't afford it. How do you apply the test?
Well, my lady, you have to apply the test to the right, which is part of the reason for starting with the A2P1 right in its nature. The submission I'm going to make when we come to the religious and cultural position in 149 and 156 and that those passages in the judgment, the submission I'm going to make is that the state is entitled to have as its policy something which says, well, we don't have to support provision of private education in circumstances where there is already available a national state system of education which is pluralistic and non-denominational. And so to deny the right you have to deny the right to the child to education. That's the strictness of it.
Well,
And it's for the state to decide how that education is provided, by what systems, pursuant to what permissions, what is supported, what is the subject of a tax regime of a particular kind. Those are all matters for the state to judge, in particular for Parliament to judge.
this is why it puzzled me that you left out of account the second sentence, because I don't think the first sentence can be read without the second sentence very sensibly in the context of this case. And the second sentence says, in the exercise of any functions which it assumes in relation to education and teaching, the state shall respect the right of parents to ensure such education and teaching in conformity with their religious convictions.
Yeah.
So the question is whether you are denying these people the right to education in the context of the state assuming a taxation function, because then that prevents certain people having their education in conformity with religious convictions. You might say, well, they can be homeschooled and so on. So
Well, they can be homeschooled, and there is state education provided. I'm not excluding the second sentence. Just the argument below and here is always focused on the first sentence and the impairing the essence of the right. We know from the Strasbourg case law that when you get into the second sentence, those policy choices and those balances are all inherent in that second sentence as well. And that what that does not mean, that sentence is if only the parent says, I need to, or I wish to send my child to a private school which more closely conforms to my religious and philosophical beliefs, they have, as it were, a right to do that. There has to be a right to respect with all of the choices that are inherent in that.
you have to consider the second sentence when you answer my Lord's question as to 90%.
Well, my lord, yes, and I have to answer that in relation to essence of the right as well. Does it interfere with the essence of the right in one? I'm not seeking to exclude the second sentence. I'm just saying that the themes that were identified from the case law, sentence 1 and sentence 2 by the divisional court, were accurate. And what they do is to recognise the breadth of the choices that have to be made, the difficulties of these balances, because very often, most of the cases involve parents holding very strong beliefs, religious or otherwise, about how their child should be educated, and the state either not providing that or compelling them to go into a state system which does not in terms deal with that or does not conform to their beliefs, or not providing the requisite support, as the parents see it, for a system of that kind. And what the Strasbourg case law is thoroughly against, as it were, is some form of absolute right that the parent says, my belief is that this is the way it should happen, and the state is then either obliged to provide that or is obliged to support that financially in some way, whether by direct subsidy or through favourable tax treatment.
Well, you have to respect it.
You have to respect it with all the balances that are inherent in it. And that's what the Strasbourg case law grapples with.
There must be a stage at which you're not respecting it if you tax it out of existence.
Well, my lord, there's a question about that, but we're not, I respect,
That's the
submitting
question
that
I'm
territory.
asking, yeah.
Yes, you'd then have a sharper debate, perhaps, about the availability of the state system, because in a lot of Council of Europe countries, including ours, there is a state system which is essentially designed to be pluralistic and non-denominational.
Completely unacceptable to, for example, the Haredi community in this country. And I know Mr. Broach is not advancing this particular legal ground of appeal on this appeal, but we have, in the context of the Article 14 complaint, I know you're going to come back to that, or Ms. Hannett will come back to that.
Yeah.
But the foundation for it, at least in part, is the evidence of Mr. Pinto, who, and various findings of fact were made by the divisional court based on that evidence. And certainly as I read it, it's very stark that, for example, in the London Borough of Hackney, 1/3 of children attend one of the private Haredi schools that we're talking about. And for a great many of them, perhaps not all of them, for a great many of them, they are simply not going to be able to afford the new fees. And so they are faced with a very stark choice in the real world, which is that you send your children to a state school, and I understand all your point about pluralism and so on, but that's completely contrary to their beliefs. So they're forced to violate their own religious beliefs by sending their children to school. And it's not just a question of preference. They feel that strong sense of I am breaching the code of my religion. So that's one option they're faced with. The second is homeschooling. And it may be that in reality, you say, well, fine, you're not prohibited. But that is. But are there, on your analysis, am I missing something? What are the choices that they have?
Well, the other one in time, and of course there is a time problem with it, is a movement of the private school into the state sector.
Yes, this is the voluntary aided.
Yeah, but I'm not going to pick up all the points I wanted to make on those passages of the judgment which deal directly with Mr. Broach's clients, because I'm going to come to that very specifically under Article 14, which is the natural place to develop all of those arguments.
Yeah.
And I quite understand why you raise it now, because the choice is a relatively stark one on the findings that were made. But when we get to it, we will see that the Divisional Court expressed the findings on the evidence pretty carefully. And a part of the answer that we give is that, as the Strasbourg case law appears to demonstrate, you have got available education in various forms. Might take a while to get there if they're moving from the private sector to the state school. Depends how many people are actually affected in a community which laudably has a very strong ethos of supporting children and supporting schools. So there's a question about the likelihood of that eventuality actually happening in the real world. But ultimately, the state's policy is that its state sector education is available to and suitable for all. And that is a perfectly acceptable policy, is my respectful submission. I mean, one doesn't want to put these things too starkly because they're always nuanced, but it's in effect, there's the education system. It provides education, and as long as you respect the rights in A2P1 second sentence, which lead to all of those principles about not indoctrinating, one can see all sorts of offence if state system, as it were, imposed religious beliefs that were contrary to the religious beliefs of its pupils, but the state sector has gone out of its way not to do that. And in those circumstances, as it were, the education system provides the education, and the cultural and religious beliefs are not being trampled on by that system. They are, in effect, being respected, and they're required to be respected. And the cultural and religious beliefs remain for the parents to pursue and to deal with in all other aspects of the child's life. As I say, that's when one gets into that second sentence. One can see the crossover between sentence 1 and sentence 2. When one gets into that second sentence, you'll see the pretty limited nature of the obligations that are imposed under the heading of respect, which my Lord the Master of the Rolls identified.
I mean, speaking for myself, the proportionality exercise is the most important part of this case, as I see it. And whilst I completely understand Mr. Quintavalle's black letter submissions, I think when you come to the proportionality exercise, there are real questions about the importance of respect for these communities' beliefs. And it's the same for both, I think, as far as I see. It's the same for the Haredi as for the evangelical Christians.
The evangelicals don't say they've got any difficulty with the state system per se.
Well, they say they do for some.
Well.
They do for some. And so people have different beliefs, and you have to show proportionality. And I think that's where the 90% argument and the various other things come into play. And the inconsistency between paragraphs 158 and 149, alleged inconsistency
which I'm going to pick up
between
specifically.
those two paragraphs of the Divisional Court's judgment. I mean, I don't want to take you out of your course, but, and I know you want to set the scene in a way, but we have read this judgment quite carefully, and we do get A2P1, what it says, and I think we would certainly benefit from your argument on proportionality being
Well, I'm certainly going to go.
taken very carefully.
I'm going to take that carefully. I don't want to lose these arguments because the arguments have been made. I've got to address them.
You've got to deal with all of them.
And the way in which that case law under A2P1 works and the facts that have come before the Strasbourg court are important as the backdrop to all of this, because they do illustrate, I respectfully submit, the careful themes that the Divisional Court drew out of them, including the policy choices, including the difficulties. And in most of these cases, they are hard. They're hard because there are strong religious beliefs or strong philosophical beliefs that education should happen in a particular way, and how does that work with the provision of education within a state system? They're almost invariably on that, in that difficult
I don't
territory.
want to take this, you to take this as a knee-jerk. We have limited time for your submissions. The way I see it, speaking only for myself, is this is a discrimination case. Very interesting educational background, but the real nubber, the real heart of this case is whether these groups have been discriminated against in an appropriate way or not. And so I'd certainly benefit from some time being taken over that.
I'm certainly going to do that. Can I take this much more quickly?
Yeah, and we'll try and...
The impair, I'm just dealing with the impairs the very essence of the right argument, which is still being maintained.
Yeah.
The one-line submission, if you want it reduced to that,
Yeah.
is that the Divisional Court's judgment was correct in its analysis of that. And the relevant paragraphs for present purposes are paragraphs 60 to 65.
Yes.
And we respectfully submit that that is a perfectly proper and correct analysis. In essence, there's no duty to facilitate access to any particular educational facilities, and one can tie it back to the lack of any obligation or requirement to fund, subsidise or provide social assistance for particular forms. And the idea that VAT is a direct tax on education, as it were, was specifically considered in those paragraphs, to the extent that that's said to be objectionable. But the Divisional Court considered that and reasoned with care, and we respectfully submit they were right to do so. So that's A2P1, nature of the right. A1P1, in other words, if I'm dealing with engagement or interference with the Article 1, Protocol 1, the property right, the possessions right, that's dealt with in the judgment at paragraphs 238 to 249. I'm going to make one specific point about justification, but the points perhaps to pick up in light of the submissions that have been made relate to no possession or no interference. The definition of a possession is well established under the Strasbourg case law. It was considered by Kenneth Parker QC, as he then was, in the Nichols case, particularly paragraphs 70 and 71, page 296 of the authorities bundle. And that passage and that analysis is of some real interest, but not least because it was approved by Lord Bingham in Countryside Alliance at paragraph 21, as you'll recall. It's that distinction between future income and goodwill, however strange in accounting terms, too strict an insistence on that might be.
So it was paragraph which in Countryside Alliance?
21, approving Kenneth Parker QC's analysis there. The case law is reviewed, if you go to the Divisional Court's judgment, to 239 to 244. You'll see all the various case law considered. You'll see the Nichols case referred to at 240. and also Brer, Lord Dyson, C243 of the Divisional Court's judgment. And we respectfully submit that that was the distinction that was critical for the Divisional Court, and they concluded that this was on the future income side rather than the goodwill side, if I could put it in a very brief summary. And they're applying there, it's to be borne in mind, they're applying there the specific case law, particularly from Brer, paras 40 to 49, but really 43 and 44 are the key ones in Brer, key paragraphs in Brer. Brer is, the relevant bits are at 532 in the authorities bundle, if you want to check back on those. My learned friend Mr. Quintavalli, I should note, is right about Countryside Alliance having found an interference with possessions in A1P1 on the facts. So there appears to have been a misunderstanding of the Divisional Court's reasoning in 245 in that respect. But my submission is that that makes no difference to the overall analysis. What they're effectively doing is to apply that distinction derived from Kenneth Parker, adopted and approved by Lord Bingham in Countryside, and then adopted and approved by the Court of Appeal, Lord Dyson in Brer.
You may be coming on to this, but what is your response to the argument that if the existence of the institution is threatened, its viability of the school is threatened, it is, let's say, for the sake of argument, it becomes no longer viable. This is the straw that breaks the camel's back. Does that make any difference?
My submission is one needs to be a little bit careful with that, because that doesn't touch the question whether a possession is involved.
Well, I'm not. Maybe you need to explain why that is.
Well, that bit of the judgment in Brer, I think, was to do with interference. They were worrying about whether a consultation paper interfered with a possession. But
let's take it back to principle.
Yeah.
Nichols does query whether marketable goodwill, by the way, always means marketable goodwill. It seems to me, on the face, the starting assumption might be that these schools do have goodwill. They are existing institutions that attract clientele. If, for the sake of argument, it could be shown that this measure would have the effect of forcing closure, why does that not interfere?
Well, perhaps if one could get that, perhaps if one could go down that route.
You may say it's not there on the evidence. That might be the answer.
Well, that was the finding in 245. There was no evidence that the challenge measure caused any diminution in the present day marketable value of the school's goodwill.
Well, yes, except they focus on so-called marketable goodwill, and I'm not quite sure about that. So, which is why I'm asking the question.
Well, I think if you're asking me the question of broad principle, if you can show, for example, that a state measure might put a company out of business, then you'd have a more powerful case for that being an interference. Because,
indeed, as in Countryside Alliance.
Yeah, because most businesses have goodwill, as it were, inherent in their structure. So I'm not shutting the door to that in principle. But there is this, might be thought slightly strange. I think the Divisional Court found it slightly strange. I think they called it unsound at some point, but that slightly strange distinction between future income streams and goodwill, because the two can be obviously interrelated. Yeah. There undoubtedly are cases. You've got all those handgun cases, which was Ian Edgar, post the Dunblane tragedy, and the ones about cattle head deboners in the light of that crisis. Those ones were rejected as inadmissible on that ground. It was just interfering with future income streams. So there is that quite difficult divide. If you put to me the broad point of principle, if a state measure is likely to put an ordinary business out of business, then is that an interference with a possession? In many cases it might well be. But we do rely on 245 for that purpose. I mean, maybe something of a non-point, because all that this ultimately leads to is into a pretty similar looking set of justification arguments.
Yes, that may be the case. You say it ultimately doesn't matter.
I say it ultimately doesn't matter, but I also do defend the way in which the Divisional Court dealt with this prior issue, both in relation to schools and in relation to parents. You'll remember in relation to 248 of their judgment, in relation to parents, they addressed this question as to whether a tax is always an interference with possession. They conclude that it isn't necessary. It depends what the nature of the tax is. Oh, I'm sorry, I know my Lord Justice Singh was
No, I was only
on the threshold of the
I
question.
don't want to take you out of order at all, but you faintly hinted just there that if you get into justification under this protocol, A2P1, that it'll just be the same arguments as justification for discrimination. I'm not sure, speaking for myself, that's right, actually, because it might be that it's much easier to justify an interference under A2P1.
Yes, my Lord, I'm going to divide
A1P1.
I'm going to come to my submissions. I'm going to deal first with justification under A2P1.
Yeah.
You're right, discrimination introduces a different angle. But in relation to A2P1 justification and A1P1 justification, the two look remarkably similar. But discrimination brings the additional angle.
If somebody just complained about a general tax measure, and there was these appellants were not here, but it was just generally people who say, we want to send our children to Eton. We have no religious views, but we don't want to pay this new VAT. I think you would say, well, they're going to be given short shrift. And if all they can complain about is an alleged breach of A1P1, because there will be a very wide margin, you would say.
And the tax is referred to specifically over all of that.
Exactly. That's all I'm getting
Yes.
at. The justification issues are not necessarily the same
No, they're
when
not.
it comes to discrimination.
My Lord, I shorthanded this.
Yeah,
it's much closer. You've got A2P1 justification, A1P1 justification, then obviously discrimination brings the additional elements that we know and love, as it were. I want to pick up one point on principle in relation to justification, while submitting overall that paragraph 247 of the judgment is right. But there seemed to be some suggestion, I think by Mr. Quintavalli, that there was a separate, as it were, public interest bit in the proportionality exercise, which added things to the proportionality exercise in A1P1. And true it is that A1P1 is cast in terms of public interest. But if one looks at the relevant case law that he relied upon, I'm not going to invite you to go back to it now because it's a pretty much subsidiary point, and you look at the structure of the article, you'll see that the reference to public interest in A1P1 is really a reference to the legitimacy of the aim of the measure. Is it pursuing something which is in the public interest is treated in effect as equivalent to the legitimacy of the aim? So that if you go to NKM, which was the case he went to, and you look at the structure of the analysis between paragraphs 55 and 60, that's page 1728 for your note in the bundle, you will see that the public interest bit of the analysis deals with what we would traditionally regard as being legitimacy of aim. What's the measure trying to achieve? And then when you get to proportionality at paragraph 60, it doesn't bother with legitimate aim because it's already dealt with that. It just goes on to fair balance and less intrusive measure. So the slightly different formulation of A1P1 is really the short solution. Does not lead to some difference in terms of the basic test for proportionality. Public interest is just being used as a different label for the legitimacy of aim, effectively.
Are you going to deal in this context with the EU directive?
No, I'm going to deal with that in a moment.
That's
under
fine.
consensus
That's fine.
when I get to margin.
Well, I think Mr. Quintavalli does make the distinct submission that it's already being determined that the imposition of VAT on education is not in the public interest, and therefore he says that's the end of the inquiry.
Yes, my lord, he does say that, and my submission will be that's obviously wrong.
I see.
But the reason that's obviously wrong is because it ties back into the submission I'm going to make about the nature of the consensus and how that works in the convention scheme. And if it works that way in the convention scheme, generally, under proportionality, the references to public interest in A1P1 don't advance matters. Must work in the same way there. I wanted to pick up one point on the facts, which he says, well, you can't demonstrate as a public interest because this is not hypothecated. And the Divisional Court acknowledged that it wasn't hypothecated in the judgment at paragraph 76, but they nevertheless noted accurately that the government was raising this money, albeit not hypothecated, very specifically in order to meet various commitments to put further funding into the state sector, including in particular the provision of special educational needs funding, which is really the cornerstone of the challenge below, the SEM category. And they were right to put that rider on it, as it were. Can I just give you two references into the evidence which make clear those commitments, even though not hypothecated? So hypothecation, we say, is an irrelevance. This was money being raised for that purpose and to deal with those commitments, albeit that wasn't, as it were, as a matter of government accounting, specifically ring-fenced in that way. Doesn't need to be. Scarlett Graham for the Treasury, in her statement at paragraphs 20 and 68A, deal with this hypothecation point. And that's in Supplemental Bundle 1, tab 24, page 241 is paragraph 20, and 250 is paragraph 68A. And Ms. Whitehouse, who's DFE, her first statement, paragraphs 89 to 91, sets out a list of matters the government was committed to raise money for. That's Supplemental Bundle 1, page 232. Can I turn then to justification? And at the moment I'm on A2P1 and or A1P1. I'll come to Article 14 in due course. But on A2P1, the principled approach is dealt with in the Divisional Court's judgment at paragraphs 83 to 87. Headed margin of appreciation / discretion. They cite the very well-known Bank-Mellat test at paragraph 81 of their judgment, page 181. And the margin or respect principles are also now very well set. The key authority is the unanimous Supreme Court in SC, which is page 760 and following in the authorities bundle. And the submission in relation to A2P1 justification and the approach in principle is that the margin is a very wide one, reflected in the phraseology manifested without reasonable foundation, if you wish for that. There is some caution with that language for the reasons given by Lord Reed in SC. And the reason in principle it's wide, is very wide here, under A2P1, just generally as it were, is because, one, we are squarely within the territory of social and economic strategy. We're dealing with the raising of public money through the taxation system, choices based on social justice as to where and how spending priorities should be set. And in a validly, as the Divisional Court emphasised, redistributive measure, or aim here. And that was a key widening factor, if I can put it that way, identified by Lord Reed in SC, C in particular, paragraphs 115.2. I'm sure SC is very familiar to the Court. I'm very happy to go back to it if you'd like me to, but it will be very familiar, I suspect. And then the key passage, perhaps, drawing the strands together between paragraphs 158 and 162. That's at page 821 in the bundle. We're squarely also within the territory in which the choices or the judgments that have to be made are about issues, whether VAT should or should not apply to private school fees, which are paradigmatically legislative in nature. There isn't any right or wrong answer to any of this. And we do emphasise the well-known passage now in paragraph 162 of SC, in which, in effect, Lord Reed urged some caution about the courts being sucked into, not least because it was so easy to raise discrimination claims, because wise differentiation was the art of legislation, in effect. It's that paragraph. But concerned about the courts being dragged into what are, in effect, policy, political, or legislative choices. And of course, that isn't as it were, a novel thought. You had precisely the same thought or concept being expressed by Lord Bingham in Countryside Alliance in the context of the ban on hunting, at paragraph 45, page 340 in the authorities bundle. And on the same theme, Lord Justice Leggett in SC in the Court of Appeal, in effect, can I just invite you to go to that briefly. It's behind tab 29, page 632. The paragraph I want is 87 and 632. Can I just invite you to cast your mind down 87? And then 158 on page 652. If you could just cast an eye down that paragraph. I mean, as I say, you see many of these themes, or most of these themes, reflected and agreed with in his own language by Lord Reed when it went to the Supreme Court, but it's a useful exposition, I submit.
Do any of the authorities make the specific point that where you're dealing with tax,
Yeah.
that under our constitution it's the House of Commons, not just Parliament generally, the House of Commons has a particularly protected role under our arrangements, I mean, ever since the conflicts of the 17th century, and indeed the People's Budget of 1909.
Yeah, I'm not sure any of the case law specifically refers to that, but tax is identified in some of the Strasbourg case law as an area particularly attracting a broad margin. And indeed, I think the Divisional Court in paragraph 85 referred to at least one of those cases for that proposition.
Well, don't take time over it. I just wondered if anyone had made that.
Yeah, they cite Guberina, and they cite Wallishauser and Austria number 2 in the second half of paragraph 85 for precisely that proposition. Unless my lord was making, were you making a domestic constitution?
Yes, I was. Yeah.
They do.
For what it's worth,
Yeah.
that seems to me to be a point of our domestic constitution. I don't know where it takes one, but I was just wondering if anyone had ever made that observation. Seems to me to be right. But I may be wrong.
I'm not sure. They certainly have a role of bringing things in the way in which it was brought in this case, which led to the hiatus before the primary legislation was passed. But for my submissions, it's enough to say taxation as a field falling paradigmatically in this set of principles. And ultimately, Parliament, through primary legislation, does consider this change both in the Commons and in the Lords. So you, in effect,
Well, they don't consider it in substance in the House of Lords because it's certified as a money bill, which I think is my lord's point. But what it does maybe is reinforce the democratically elected point. It's the House of Commons that gives the
yes, there was certainly some
consideration.
yeah, there were certainly some debates in the Lords about it. I think we've got references in at least one of the witness statements to some debates in the Lords. But anyway, it matters not for present purposes. This is a matter of internal parliamentary accounting, as it were, how they go about passing it has the democratic stamp, however they choose to do it. But in Strasbourg terms, which is what Lord Reid was specifically interested in and considering, and so was Lord Legate, you end up with those with the breadth of margin that is afforded in socio-economic areas. Anyway, and of course, fourth point, the third point was the tax system as a paradigm example. The fourth point is domestic and constitutional reasons. Again, all now work through in this SC line of cases for broad respect here. Here we had, as you know, initially the resolution with the House of Commons and primary legislation being passed through Parliament. And as the judgment of the Divisional Court of paragraph 4 noted, all of that was preceded by a pretty extensive process of consultation. And it reflected a manifesto commitment made in the Labour Party manifesto before the election. The fact that that's the background, or that's the context, is of some interest, as the Supreme Court noted in SC at paragraph 209, that, as it were, brings it squarely within that democratic sphere. There was a manifesto commitment likewise in that case that was under consideration. But the top court has frequently made the point that primary legislation is at the very apex of that constitutional hierarchy in terms of respect. So it is of some significance here that we're dealing with primary legislation, however made. That's a matter for Parliament, how it chooses to make things, subject to their privilege. And of course here, in the context of A2P1, we're not necessarily dealing with or having to be concerned about, although I'll come back to it under the A14 argument, with a suspect ground. Can I turn to consensus? I know my Lord asked about that. Maybe it's sensible to pick that up now. That was a matter that was dealt with in some detail by the Divisional Court at paragraphs 89 to 95. That's where they deal with consensus or convergence. And again, my short submission is that they were correct in their analysis in those paragraphs, including in particular 93 to 95. But they set out with some care in 89 to 95 their analysis. And I submit, and they found, that it isn't every consensus that narrows the margin. And the idea of the consensus playing into the Strasbourg Court's analysis is almost invariably tied to the idea that the convention is a living instrument. And that means that it can react to changing societal values and mores. Our friend took issue with the references to moral, but it's really that societal values changing issue. And that is why it's no great surprise to note that in almost all, if not all, the Strasbourg case law, where a consensus has been relied upon in the Strasbourg Court's analysis, it's been within that sphere. So the classic example is corporal punishment, and most particularly sexual orientation and all the issues associated with that. That was the subject of Alan Kane and so on, but very often within that.
I don't think you put it this way, but can I just ask this as a question? In terms of the directive,
Yeah.
the education exemption is clearly listed as a public interest matter that is relied on. You've just talked about living instruments, and a moment before that you talked about a manifesto commitment. To what extent do you say, might you say, that if there was previously a consensus, it no longer applies?
Because of the manifesto commitment.
Yes.
Well, I think that is a point that can be made. I was going to make the rather more basic point. That I think is a perfectly fair point, and to some extent one can say, well, if there was a consensus, it was changed when Parliament considered it and changed the law.
Or possibly when Brexit.
Possibly when Brexit happened, and we were no longer bound. Exactly.
Government
So one can take it at various points in that spectrum, but I respectfully agree that that is a forceful point. I think the way in which the divisional court particularly approached it was to say, well, what really is happening in the directive anyway is something which isn't, as it were, of the type that Strasbourg has taken into account in the past when considering consensuses, because the fundamental driver for the directive was creating frictionless markets, frictionless borders. So it had that classically EU perspective, and even if one looks at the title of public interest, that in itself is regarded as a very strong public interest under the European system, which we've now left. But my submission on consensus is that if you can't just turn up with any old consensus, it has to be a consensus which is, as it were, related, takes one into the space of being related to the scope of the right that the Convention affords, or the nature of the right that the Convention affords. And given that it's a living instrument, it can change as societal values change. The court's very cautious about that because it may change at different speeds in different countries. But if there is as it were, a non-human right explanation for the particular consensus in question, as here there is under the directive, because it's all about pursuing those EU objectives about markets and frictionless borders, and that simply doesn't take you into the territory where you can say, you can take that consensus and transpose it into a thing that says, so you can't justify it under A1P1, for example. And the reference to public interest in the title above, Article 132, or whichever article it is in the directive, doesn't get you there, because as I say, there's an EU public interest which has got nothing to do with human rights and everything to do with frictionless borders. And that is, rather elegantly summarised, the core of the reasoning, I think, in the paragraphs to which I referred of the Divisional Court's judgment, 89 to 95, which you respectfully submit are correct. I've dealt with the principle, how you approach justification in principle. I wanted to very briefly deal with the vexed question of Schwidler.
Oh.
My Lord Justice Singh posited the question, how would ED address the Supreme Court if we went against him in this court? Which
well, if the divisional court, if in the present case the divisional court had gone the other way,
yeah,
what would you be saying to us?
Well, my Lord, I never quite knows what I'm instructed to say. I'm sure to answer that. But one might be a bit cautious about building anything too much on that. I mean, as my lords are very well aware, having sat in Schwidler, you've had this debate before, and the Supreme Court had the debate again, and decided that they didn't want
greater length.
They didn't want nice, clean lines. They wanted multifactorial, and everything gets thrown into the pot. To some extent, I mean, maybe the way through Schwidler, or at least to some extent the way through Schwidler, is this: there is obviously a concern at the appellate level, this level and above, that you don't end up in a position where it's just a kind of free-fall on proportionality, and everyone gets to just have a second and a third bite at the cherry. So on the application, whether you're doing it Schwidler or you're doing it ordinary principles, if I can put it that way, the appellate court will inevitably start with the judgment of the court below. And here we have a three-person, very senior divisional court, which has produced a very careful and detailed judgment, making a series of findings of fact, very few of which, if any of which, are actually contested on this appeal. And that should be your starting point, is my submission, whichever approach you adopt. And so the question really is, are you in territory where trying to apply the multifactorial approach and noting, of course, Schwidler Supreme Court paragraph 60, to which I think my Lord Justice Singh drew attention, are you in territory where you think this is a case which raises sufficiently important points of principle as opposed to just being a challenge on individual facts? And of course there are a myriad of different circumstances in between those things. And the slight concern with taking judgment in the Supreme Court paragraph 62 broadly is that by the time anything reaches this court, a fortiori the Supreme Court, it's almost overwhelmingly likely to be a new point of, or a new application of
No,
an
but this is
important
new
point.
legislation, difficult legislation, high profile, public interest in the case itself and in the problem it poses. It seems anyway to me that we would be poking our finger in the eye of the Supreme Court if we were to say this is a case where we don't have to consider proportionality. Obviously, looking in the first instance at the judgment below and
Yeah.
taking whatever we can from it, including the findings of fact and the very helpful.
Well, my lord, I'm not going to die in a ditch over this point, frankly.
No.
I mean, one can see the good sense and force of all of that. I may respectfully say so.
I've never heard the expression "die in a deck chair," but I rather like it. Maybe I shall use it myself.
But the only reason I'm
It was a ditch, actually.
the only reason I'm in the ditch at all is because there is a broader question here about quite how one goes about operating this principle in a way which doesn't lead to all sorts of difficulty and administrative chaos in virtually every case, because everyone will say, I've got a new statutory point or a new context. And obviously, this Schwidler point only really applies to proportionality. If there are issues of principle that have to be resolved about the nature of the right, how you go about doing discrimination, all of that, those are just issues of
But
principle.
this case is a case where leave, permission, has been given
Yes.
on the basis that it's a case of great public interest and importance, and in those circumstances that might be a starting point. And what is said against you on proportionality is there was an error in the evaluation.
Yeah.
And if there's any substance in that,
If that's right, it would open it up anyway.
open it up anyway.
Oh, yes, so that's...
I mean, for my part, I don't think you do need to spend a great deal of time
No.
on this. I think
I simply
we
put
will-
down the marker about how it's expressed, because one doesn't want to, as it were, to create...
I'm sure my
an
lord and I
entirely
will take
field.
very great care to ensure that we don't reopen Schwidler.
Right. Faithfully applying the Supreme Court's reasoning, no doubt.
Faithfully.
My lord's application, the application of A2P1 justification, legitimate aim, the relevant paragraphs or the key bits of the judgment, so far as that is concerned, are 18 to 22 and 109.
Sorry, I didn't catch the point you were making.
I'm going to A2P1 justification,
A2P1 justification, thank you.
which can be taken to apply to A1P1 as well. Now I come to discrimination as a separate topic.
Yeah.
Legitimate aim, you've got the four interlocking aims dealt with and identified in particular in the evidence of Scarlett Graham, the Treasury witness, paragraphs 65 to 68, supplementary bundle 1, page 253. They're summarised correctly, as we all agree, in the judgment of the Divisional Court at paragraphs 18 to 22. Very large sums of revenue involved. The assessment which the Divisional Court accepted that it was 1.5 to 1.7 billion annually, and then you need to take a relatively small number off that for transferred pupils. But as you'll recall, they were particularly attracted by the certification from the OBR in relation to those numbers. And that money was being raised, back to the hypothecation doesn't help my friend point, to help the government fund its priorities for education and young people, including investing in state education, with all of the benefits that would bring to the vast proportion of people, children who are educated in the state system. So raising revenue, 1, fairness, 2, and there's basic points there about social judgments that have to be made, and redistributive effects of taxation. And as an aspect of fairness, making judgments about protecting those with the most acute needs, including in particular the SEND children. And then administrative burden and minimising the potential for abuse. So if one goes back to the judgment with those aims in mind, one goes back to the judgment at 109 to 115, you'll see that the Divisional Court deals with the first two questions, legitimacy of aims and rational connection together. They deal with those at 109 to 115, and my submission is that they were correct in their reasoning there. And they consider, you'll note, the position of low-cost schools at 115. Just to note that specifically, given the way the appeal is narrowed. And they deal with less intrusive means at 116 to 119. They highlight and emphasise correctly that less intrusive means, I think we got this, we could take this from my Lord Justice Singh's judgment in Schwidler as well, but less intrusive means, as the case law now clearly establishes, not unacceptably compromising the objectives pursued. It's that point from, I think originally from Lumsden. But what that means is that you've got questions of judgment, attracting margin there as well, that stage of the analysis also. My submission is that, therefore, the judgment paragraph 118 applies the correct test, and there doesn't seem to be any challenge to that. There was a challenge below, I'm not sure to what extent it's pursued now, still, I think it maybe is in writing, but wasn't dealt with orally. There was a challenge to the timing of the measures, their introduction. That was dealt with at 116 to 118 in the judgment, and if and to the extent that it is pursued, the evidential basis for that we've collected together in our skeleton at paragraph 48, if you need them. And so far as exemptions are concerned,
sorry, skeleton paragraph.
Paragraph 48.
Thank you.
Sorry. So far as exemptions are concerned, as you see from 119, they consider those better dealt with under the heading of discrimination. That was the structure of their analysis. And then fair balance at 120. You see the reasoning, and again, no one seems to have had much of an attack on that in relation to A2P1. We respectfully submit that's correct. So can I turn to discrimination?
Sorry, you said A2P1 justification with the same points for A1.
Same points for A1 and P1. That was in essence the reasoning of the Divisional Court as well, I think. To the extent it interferes with property rights or possessions, it does so for good reason. So far as justification is concerned, we'll touch that with, I think, all the other points about ambit and status, all the usual precursor points have rather dropped away. This is about justification under discrimination. I start with the approach in principle, if I may. The core principles are set out in the Divisional Court's judgment at paragraphs 122 to 135. I'll come back to the point, but we don't have any quibble with those, but you will note specifically, if I can invite you to note it specifically, you will note specifically 135. They deal with margin, and they draw the threads together in relation to margin, including...
Forgive me.
Sorry.
They say a lot about margin, as you say. where do they actually pose to themselves what the test is that they have to apply in deciding whether there is justification?
Well, they're in I think that's later on in the analysis at 150 and following. Where they say it doesn't matter unduly how you approach it, which door you approach it through, it's ultimately the same question. But 150, I think, is closest to my Lord's question to me. In practice, the question is, it's that second sentence.
Yeah, but again, the question they're posing to themselves is, does the decision to impose a uniform rule fall within the applicable margin of discretion? Which suggests, but I'm still not seeing what the test is for justification. What is it? Do you have a magnifying glass where you can find whether this is there's an applicable margin of discretion, apparently, which suggests some kind of spatial metaphor. You try and find this area, the margin of discretion, and you have your judicial magnifying glass, and you find it's in there, is it? But where do they actually pose what the test is that they're applying, giving a margin to Parliament?
Well, I think what they do in their analysis, in fairness to them, is to say, well, the challenge here is to exemptions.
Yes.
And the question is not treating them more favourably justified. They've gone through all the Thelimenos analysis earlier on in the passages I've already indicated, and they ask the question: is that justified? Are there good reasons for not treating them differently? And if so, what are they? But in applying those reasons, and they then come on to consider the various justifications that were advanced, and they consider them in terms and apply them to the question, should an exemption have been created? What's the justification for not doing so? But they shorthand the question, as it were, because they recognise, we submit correctly for reasons I'll come to in a second, that in answering that question, Parliament has to make the judgment. Should there be a general rule, or does there need to be an exception created because of the weight of the interest? And that is the way that they've approached it, as is clear from the judgment. So they're asking the Thelimenos question, but they're recognising that Parliament has a broad margin in answering it, albeit narrowed to some extent for reasons I'll come to. But that's the way they do it, and maybe you're right, 150 looks like a bit of a shorthand, but it's preceded by that earlier analysis, which is to some extent quite complex as to how precisely you go about doing it. You'll remember the debate in relation to indirect discrimination, Lady Hale saying, look at the measure as a whole generally, and direct discrimination, if it was that, you look at the reasons for the difference of treatment. Thelimenos is a bit like that, or closer to that. So we're not just looking at the measure generally, is what they say, we're looking to see what the reasons are for not creating the more favourable treatment, but in applying that, its margin. That's how I respectfully submit the judgment is structured, and I respectfully submit that's right.
The words are all very fluid, aren't they?
They are.
I mean, we look at SC and we get every paragraph seems to have a different metaphor.
My lord, it does, and one can go back through SC endlessly and get to roughly the same place. The answer to that, I think, where it ultimately gets to is they acknowledge the Supreme Court, and they clearly acknowledge that if you're in an area, we're kind of back to Lord Justice Leggett in C in the Court of Appeal as adopted by Lord Reed in the Supreme Court in SC when it got there. But if you're in an area in which you are having to grapple with judgments about whether exemptions should be created, about whether the policy reasons that lay behind according a particular type of exemption existed or don't exist. If you're in that territory, you are necessarily in territory which the Strasbourg Court has repeatedly recognised accords particular respect to the nation state.
But it's not a blank cheque.
It's not a blank cheque.
And that's the problem here because we are dealing with discrimination of a particular kind, which was actually considered, which may be a point in your favour, but it was actually considered, and it has a serious real-world effect on real people who are affected very badly by the blunt instrument nature of the measure. And in that situation, it's all very well saying Parliament is to be allowed a wide margin of appreciation, or whatever words you want to use, but
You still have to justify.
yes, and that's a question when it's a very serious matter, like discriminating against a very serious number of people who have real-world interests in not being prejudiced.
Yeah. My Lord, none of that I would disagree with respect.
So that's why I find the case, if I'm just putting it bluntly, I find the case difficult because I'm completely, I shouldn't say this, I'm very much assisted by the judgments in the Supreme Court, but they don't give me the answer.
They don't give you the answer, but what they do, and what you mustn't ignore, if I'm allowed to put it this way, is the fact that almost every case which has gone up to the Supreme Court in this sort of territory has emphasised the breadth of the margin when you are dealing with difficult social, economic, redistributive judgments, tax. When you're in those areas, there is a real constitutional line, which is that it isn't for the court to second guess.
We're always talking about the breadth of the margin.
You're always talking about the breadth of the
Remember
margin.
in the Prince Harry case.
Yes, but it doesn't mean
I talked about nothing else.
as you
I was very badly criticised.
as you pointed out in that case, and no doubt as others have pointed out. I mean, this does not mean that the court is abdicating its responsibility to review the justification. This is about the mechanism and the method by which you go about doing that.
Yes.
And it is an important constitutional point. I don't want to lose sight of it. I'm not going to keep banging the drum. And in the paragraphs that I'm about to give you, you will go back and no doubt throw up your hands in horror because you will see on the one hand this and on the other hand that.
But that's the point.
On this broad thing in socio-economic but weighty reasons of your suspect growth.
I mean, what we're looking for from you is help.
Yeah.
If you can offer it. I mean, you can take as read that we know the language that has been used at the highest level about how important it is to allow government, particularly in a measure of this kind, which has been passed after a manifesto commitment and massive consultation, and it's a political and for the elected government and in a democracy to deal with. Of course, all that is taken completely as important and read, but
it's how it applies in this particular
how it
case.
applies in this particular case, where there are real-world consequences.
I'm going to come to
for
that.
people,
I'm going to come to that absolutely directly.
which you can probably already see the court is concerned, not to ignore.
Yeah, and I'm going to come to that absolutely directly, and I'm not going to duck any of that, and I don't say that wide margin is a complete answer to any of that. But there has been a debate of principle before you about how the two correlate. In other words, how weighty reasons interacts with the big, broad social margin. And my submission in relation to that is that if you go back to the paragraphs in the Supreme Court where Lord Reed seeks to grapple with that issue, the ultimate conclusion is it all depends on the circumstances, but you can have a context which involves weighty reasons, in other words, discrimination on what might be called suspect grounds. The question is how far we're into that territory here because of the nature of the exemption contended for, but where you're in territory of suspect grounds, you can nevertheless apply those base constitutional principles of respect. So you've got the two sitting together. That's my first point. So just to give you the references very briefly into SC, and then I'll shut up about this entirely, but it's 100, 103, 120, 129.2, 130, and then the key bit, pulling it all together and trying to derive the principles, 158 to 162. But as ever, you get as much from how the principles are actually applied in working practice in a judgment as you do from their expression. And if you go to the reasoning of the Supreme Court in relation to the two-child rule there, you need also to read 206 to 208, because it's evident that the dispositive thing for the Supreme Court when it came to it was that this had been, it was in that territory, socio-economic, difficult judgments, judgments for which there is no legal yardstick, as it were, all those points that Lord Justice Leggett made in the Court of Appeal that were adopted by the Supreme Court in SC. When you go to 206 to 208, which are the really critical paragraphs as to how the case was disposed of, you find those to the fore. And I respectfully submit that that is of some real interest. I made the point, it's a point I may have to come back to, I made the point already, if you're dealing in our context with the exemption contended for, what you're actually dealing with is the low-cost exemption. And so, to some extent, that over-includes and under-includes, and although you've got, undoubtedly, some correlation, some overlap between that exemption, that formulated exemption, and those with strong religious and philosophical beliefs in particular. So you are dealing with that territory, those sorts of rights and interests. There is at least a question as to how far you're into that territory for this purpose, particularly given the nature of the exemption it is contended for.
I mean, that's partly why my lord probably asked you where they've actually stated the test, because actually the question, I mean, you correct me if I'm wrong, but it seems to me the question, or at least one formulation of the question, is have objectively sustainable grounds been shown for the government's decision to reject an exemption on a low-cost exemption from VAT, a low-cost exemption from VAT. Now that's the main question, because actually what is pursued here is the low-cost exemption. But we're conscious that Mr. Broach put it much higher than that. He says you don't have to go anywhere near the low-cost exemption, you've just got to decide. But if one were formulating the test, that's what might have been asked.
My lord, yes, but you get that, if I may respectfully try and defend the divisional court's judgment, you get that.
No, we're not criticising.
No, you get that from their analysis of the difficult set of issues that surrounded what species of discrimination you were looking at. Mm-hmm. They plainly acknowledge and understand that Thelimenos is all about creating favourable treatment for a particular affected group. Mm-hmm. And they also understand that ultimately the issue collapses into the reasons for not creating the exemption contended for. And that's why I referred you to 150, because you do get to a focus on the reasons for not creating the relevant exemption in the second sentence of 150. And they correctly, I respectfully submit, put that together with the applicable margin of discretion or appreciation. But they are asking, why was this exemption not created? That's what they're addressing. That's the stuff of the reasoning in 149 and following of the, in relation to the heredity.
That suggests that only a factual inquiry. Why was it not created? Isn't the evaluative question for a court, are those reasons good enough?
Applying the margin.
Okay, fine, applying the margin.
Yeah.
But that's the test.
Yeah.
And again, like my lord, I don't think that legal analysis in this area, or perhaps any area, has ever helped by just having lots of words. What one needs is a principle. And therefore what I'm going to say is not intended to be just more words. I'm not trying to substitute more words for what's already been said in the law reports. But is what one is looking for, is has the state demonstrated that there are objective and proportionate reasons for not making the low-cost exemption to this general law? Is that what we're looking for?
Well, that's what that is ultimately what you're looking for, and I hate to sound like a parrot, but you do need to factor into that the idea that in relation to some aspects of that, some aspect of the reasons, yes. There's a different, it's a legal way of saying what are the reasons for not creating an exemption. But you do need to factor into that that some of those questions, some of the strands, some of the judgments as to how all this is going to work in the round, all of that does engage an area where the court shouldn't trespass. The court shouldn't provide its own answers just to that straightforward question without factoring it in.
I don't disagree. I know you know from any judgments that I myself have written, I've made that point.
Yes.
But the test is applying the margin, whatever it is, applying different levels of scrutiny. But is that where we're trying, is that the question we're trying to answer? And it is a question of evaluation for the court, albeit giving no doubt great weight to the judgment of Parliament, etc., etc. One gets all of those points. But
that is the essence of it.
Right, that's the essence.
And I respectfully submit they didn't go wrong in that. They referred to the reasons in 150, and my Lord said, well, that's just a factual question. It isn't when you see how they go about applying it, because they then seek to weigh the various factors. Are those factors coherent? Are they cogent? Are they weighty? And again, we know it's all relative and modest and so on. I'll come back to it. But they are doing an evaluative exercise. They're not just saying, what reasons has the state advanced in fact for those things? They are seeking themselves to evaluate it.
And if one of the questions that arises in answering that principled question is whether it was practical to find an exemption, a workable exemption of the kind contended for, in argument, I was asking, and I still want to try and find the answer, do we have to be satisfied that there could be, at least could be, a workable exemption of the kind contended for, if we were going to answer that question, the principled question, in the negative?
Yes, my submission is that you do. I'll come back to make submissions in detail on that, but my submission is that you do have to ask that question. The court is entitled and
obliged. You can't just live in an airy-fairy world where we say you go, you the government.
And who cares what the consequences are?
Do better.
Yes.
Yeah. One of the reasons for that, if I may add to my Lord's point, may be that we're being invited to make a declaration of incompatibility.
Yeah.
And as is well established in the case law, whether something is compatible or incompatible with the Convention rights is a substantive question. It's not a process question.
Yeah. My Lord, I fully accept and agree
and
with.
Therefore, we're not being asked to say what Parliament has done hitherto is not good enough as a matter of process. Yeah. What we're being asked to say is what Parliament has done is incompatible with the Convention rights. And that, although it's not binding on anyone, certainly not binding on Parliament, Section 4 makes it clear it's not
Parliament
binding.
does need to know to what extent and in what respect it's gone wrong.
What we do know is that in 25 years of state practice since the Human Rights Act was introduced, and this has had some implications in Strasbourg about effective remedy under Article 13, what we do know is that Parliament not only takes very seriously what a court says by way of a declaration of incompatibility, it almost always amends or repeals the legislation in consequence. So I think we do need to live in the real world where we have to be able to say to Parliament, this is what you've got to do.
Yes, my Lord, I respectfully agree with all of that, and that is a freestanding reason why you need to, as it were, raise your eyes and look at the exemption that's actually being contended for. And it's not good enough just to say, well, focus on the Haredi Jewish community and that's it, or the Haredi Jewish community and the evangelical Christians, that's it, don't worry about the consequences. But there might be thought to be a prior point as well, which is that the logic of the justification analysis, the logic of the territory into which you enter when you're asking the question, does this group or do these groups need to be treated more favourably, is to identify the group. And the group in question is defined by the nature of the exemption which is contended for. And the exemption which is contended for here is low cost.
Well, except it is, but the finding of fact that all, pretty well all, Haredi children require this kind of education makes it at least possible that another exemption ought to be considered, namely an exemption exemption for them.
Yes, but then you, yes, sorry.
Yes. Well,
But then you've got to grapple with the questions that the divisional court grapples with. You could cast it in one form, you could cast it in another form. If you cast it that way, it prompts a whole bunch of different what-if questions. I'm just on the principle and the approach at the moment. My respectful submission is that, irrespective of, and in addition to the point my Lord was putting to me, the reason for looking at this in a realistic way by reference to the exemption contended for is because a court in this analysis does need to look at the logic of making an exemption of whatever kind is being called for. You can't just say, well, there's one person who is really badly affected, and that means we have an exemption that applies to 100. You are entitled and obliged, in my respectful submission, to look at the logic of where that leads, and then to ask, well, you need to ask what the exemption that it's contended for is, first of all, but you're also entitled and obliged, I respectfully submit, to look at the logic of what the position would be if you created an exemption for this person or group.
That's the sort of hard cases make bad law approach. The problem I have, or the concern I have, is that the hard cases make bad law affect, 20,000 children. And that's a big number. So this is not just an isolated instance of one person saying, I've got a special, completely eccentric belief and I need some special treatment. This is quite a big thing.
Yeah.
And that's why, for my part anyway, I want to hear why an exemption can't be fashioned that is objectively reasonable. I hope in a way that's quite well thought through, because I think it's a difficult point.
Well, can I cut to that? I'm not going to make submissions about bright lines. You have the well-established and well-known points about bright lines. Again, it rather depends how bright the line is and why you're doing it. So we get all of that. But it is important at least to recognise that there has been frequent recognition in the case law that when you're setting up legislation of this kind, particularly in this sort of context, you are inevitably having to draw lines. That's the art of wise differentiation that they referred to, and that bright lines are in principle acceptable. Seemed to be some submission at some point that you couldn't have any of that. But my respectful submission is that's a well-established and necessary legislative technique. I turn then directly to the justification of the low-cost schools exemption, which is contended for, including the Reddy families. And that is dealt with in the judgment at paragraph 149, as you know, to 160. I want to note two points initially. The first of them is one we've already touched on, which is that they're not actually seeking an exemption on the basis of pure religion, as it were, for that exemption. It's both under-inclusive and over-inclusive, as I put it. For obvious reasons, I probably don't need to develop that. But it is an important feature to recognise. Second point I wanted to make was just to give you some references about where in the evidence faith schools and this issue is dealt with. So you have a collection of those if you do decide, as it seems you're inclined to go down the Schwidler route, as it were. Three references into the evidence, if I may, contains most of it. Scarlett Graham, the Treasury witness, 82 to 90. I'll pick up some of these points as we go through, but just to give you the global references.
These pages or paras?
Those are paras, 82 to 90.
It's Graham 90 that deals with the real reasons, isn't it, that why no exemption was possible.
I think that's right, but you need to look back as well. I'm going to refer you to 89, which refers to the government's policy about pluralistic education.
But I understand all
it's that passage that I'm just trying to give you the bit on faith schools.
90 struck me as very important, yes.
82 to 90, that's supplementary bundle 1, page 260.
Mm-hmm.
Ms. Whitehouse, the DFE witness, 45 to 55, perhaps especially 53 to 55. That's paragraphs, and that's in supplemental bundle 1, page 210. And then Catherine Peters, who is the HMRC witness, that's principally on the 30 million figure. 48 and 49 paragraphs, 48 and 49, supplemental 1, page 192. And my overarching submission is that the Divisional Court were right to acknowledge that there were both practical and principled reasons for not creating the exemption that was contended for, the low-cost exemption contended for. And just to take it in the order with which the Divisional Court dealt with them, 154, they deal with diminution in revenue by £30 million. I think that figure comes from Graham, I can call her just by her surname, Graham, paragraph 90 sub E, supplemental 1, page 263, and is explained in perhaps a little more detail how that figure is arrived at in Peters, Catherine Peters, 48 and 49, supplemental bundle 1, page 192. My Lord Justice Singh had a question yesterday about how that figure was arrived at, and my learned friend Mr. Broach gave you the correct references into the exhibit referred to in those paragraphs, 287 to 288. But I suspect that the most assistance you get is not really from that exhibit, which really just deals with average fees in an email, but is the explanation in the Peters witness statement. And it looks as if that didn't include too many subtleties, or indeed any subtleties, about assuming which schools might close or which pupils might transfer or anything of that kind. What they appeared to do, as appears from Miss Peters' statement in those paragraphs, was to take the average annual fee income for the 50,000 pupils, as it were, within the faith school system, if I can call it that, and then apply a net VAT recovery figure to that, which I think they took as 12.4%. So if you do 212 million times 12.4%, you get to roughly 26 million. I think that was the way it was done, so it's a pretty broad brush analysis of that kind, rather than something more subtle which assumes closure or doesn't assume closure. So that's the way the 30 million figure is arrived at.
I understand that, Sir James, and the evidence says what it says, and we can't go behind the evidence or look for more evidence. But at the point of analysis, if the premise of the argument of justification is that one of the reasons why it's justified is that £30 million or so will be lost revenue, does that assume that there won't be a lot of schools that close? Because if they do, or that a lot of parents won't be able to pay. Because if there were large numbers of schools that do close, of this type of school, I'm not talking about schools across the country generally,
yeah.
These schools that we're talking about here, if they in fact close in the real world,
yeah,
at least some part of that 30 million would never have been raised, would it?
Well, my Lord, that is true. And I think the approach that was perhaps understandably taken to that was that those are difficult questions to answer. Would the schools close? They all acknowledged, all the internal documentation, all the min subs and so on, they all acknowledge that there are risks. And there are particular risks if you've got smaller numbers of pupils and all the rest of it. So they're acknowledging the risk of closure, but they don't factor that into the headline number. You're right in principle. If large numbers closed, that number would diminish by the non-collected VAT in that territory.
And this may bring one straight back to your core submission a few moments ago. But these are very difficult exercises, which the court should not try to go behind the judgments, not just because of institutional expertise, but because of democratic legitimacy.
Yeah. Yes, I don't want to leave the would schools close. I know it was a subject that interested you, and of course I fully accept the fairness of Mr. Broach's points, which is the finances of some of these Haredi schools looks currently as though they are, if not on the edge, at least not in a flush state of financial well-being. But it's very difficult to do more than that, because there is a long and very honourable history in that community of supporting both individual pupils you can't afford and schools, no doubt. And the position ultimately is that it's a risk, and it was a risk that was acknowledged that they might close, My learned friend was asked if he was aware of any single Haredi school which had in fact closed, and it might be thought that I might well have heard about it if there had been, but we haven't heard about it, and he was not able to answer that question. So one simply doesn't know. I'm not trying to make a forensic point, but you just don't know. The risks were acknowledged. You have some of the new evidence touches a bit on this. I'm just going to give you one reference to it in the statement of Michael O'Doherty, Supplemental Bundle 2, page 1029. I don't invite you to turn it up. But there's some reassessment, as it were, there of the risks of schools closing and pupils diminishing and all of that. So that's a kind of update in terms of the evidence. But as I say, the school closures questions were addressed in various ministerial submissions. And we know that a number of private schools close annually anyway. And so you'd have to disentangle reasons apart from anything else. But in relation to at least one of the ministerial submissions, that's considered. Again, I don't invite you to turn it up now, but Supplemental Bundle 2, 726 to 727 at paragraph 10, acknowledging that the viability challenges to be particularly acute for smaller schools, which make up a significant proportion of the market. So the risk is being acknowledged, but so is the difficulty. There's an HMRC policy paper on private school measures acknowledging the difficulty of making these predictions. See Supplemental 2, page 1016, making the point that there's historically been significant turnover within the sector. There have been an average of 74 school closures and 83 new openings each year in England. This makes it, as they point out, difficult to assess the impact of this measure in terms of additional school closures. So there are difficulties associated with that. But I fundamentally adopt my Lord's point. These are difficult matters on which assessments have to be made. What the divisional court did, and it's a merit and a demerit from my perspective, is they did address the weight of this point, to go back to how they actually went about doing their analysis, to touch the point of principle I was discussing with my Lord Justice Singh. But they characterised this number as relatively modest. Again, they're trying to weigh up these factors, and one doesn't criticise them for that. That may be so if you simply compare it to the very significant number of revenue that might be raised by the measure of the 1.5 billion number. It's a relatively modest figure by comparison with that. But 30 million, it might be thought on any view, is still a significant amount of money. And who is to judge what level of modesty is to be given what degree of weight in this circumstance? It was undoubtedly a factor taken into account by government, as Graham, paragraph 90E, demonstrates, and it's obviously relevant to the issue of justification. And it was taken into account by the divisional court, we respectfully submit, correctly. And of course it will be for the court itself, if you're doing the Schwidler analysis, to bear that factor in mind. But that's what we say about that 30 million figure, which is the first of the reasons the revenue raised. Then there's practicable workability. It's the second of the matters considered. That's really dealt with at paragraph 155 in the divisional court's judgment. And C, so far as practical workability is concerned, in which I put administrative unworkability and the possibility of abuse. The key bit of the evidence to look at for that perspective is Whitehouse for the DFE, Miss Whitehouse for the DFE, paras 53 to 55. And my submission in relation to that, and again, the divisional court evaluated that, didn't decide that it was a particularly weighty factor, but did take it into account correctly, I respectfully submit. Same points I've made in relation to the number of, in relation to revenue apply here also. There are real difficulties with saying, well, that degree of difficulty will be a factor of that particular type of weight. But my submission is that the state can legitimately decide on a system that does not make it easy for abuse to arrive, and administrative workability and ease is a virtue. and one has that regularly acknowledged in those cases, particularly from the DWP sector. But there is an incentive created if you introduce, for example, here, a cliff edge. If you introduce a cliff edge which is, I don't know, if you introduce a cliff edge which is £7,000 or £8,000, then suddenly there are those incentives. Of course, one can vary that, and there are various ways of avoiding that. But if that's the cliff edge, that incentive evidently exists. And it will clearly be open to the court, and we respectfully would invite it to attach some weight to those factors. They are factors of real importance in deciding whether you have a generalised rule or you don't. The third feature is perhaps close to the heart of the attack, as it were, which is the general non-denominational policy point. And so far as that is concerned, the best description perhaps in the evidence you have of that policy, that non-denominational, pluralistic and so on policy, is in Ms. Graham's statement at paragraph 89, but it's also then reprised or referred back to in paragraph 90 sub F, page 263 in the supplemental bundle number 1.
Forgive me if I'm missing something here. So, Jane, this wasn't actually one of the 4 objectives. Is that right? That may not be that may be a point in your favour rather than a point against you. But just factually, is that right? I'm not sure where this has come in, because when one is asking if a neutral general measure has a disproportionate impact, for example, usually you look at the general measure and the objectives of that measure. And we've all seen the 4 objectives of the general neutral measure. This doesn't feature in that at all.
Well, it sits within the broad concept of fairness for all, effectively. Right. And so if there is no alternative but home education, I'll come to that in a second, then there's at least a question about that. So it does fit within that.
When you say fairness for all, as I understand that fairness criterion, it's fairness as between all private school users.
Well, my lady, I'm not sure it is quite so. Either way, there's a broad fairness question, and if there was no alternative, the child would be left without education. That would plainly factor into the analysis. So one has got that fairness point there.
I'm sorry to labour this, but this may be important. We've got the Flemenos argument, and we've got an indirect discrimination argument, and it may be that they should be treated in the same way. I'm not sure about that. You may want to help us on that. But can I just deal with the indirect discrimination?
Yeah.
Like classic indirect discrimination is where you have a general measure which is neutral, but is shown to have a disproportionate impact
on a particular segment,
on a particular group with a relevant protected characteristic.
Yeah.
That's why it needs objective justification.
Yeah.
Fine. But usually you do that not by referring to the protected characteristic itself,
but by referring to the general measure, see Lady Hare.
And its objectives, because they're all neutral.
Yes.
And they are nothing to do with someone's religion.
Yeah.
Whereas one of the concerns I have, and it may be I'm missing something here, that once one starts talking about broad pluralistic curriculum suitable for children from families of all religions and none, A, that's not actually one of the 4 objectives of the measure. But B, I start to worry that this starts to be along the lines of, well, actually, we think that you ought to send your children to a different kind of school. In other words, that it's not a good thing that you have these religious schools. But I'm not sure this is a point against you. It might be a point in your favour. Actually, if as Lady Hale said, if the 4 neutral objectives are good objectives in their own right, and if the means chosen are proportionate to achieve those objectives, I'm not sure what else you need to establish.
My Lord, you may be right. The reason we're into this territory is because the court was obviously exercised about how you're meant to approach, how you should approach the three different categories of case that they consider.
That I see, yeah.
And you can see at least some logical force in the idea that says, on a direct discrimination case, you do focus on the reasons for the difference in treatment.
Yeah. But this isn't a discrimination.
This isn't a direct discrimination case. But then they say, well, Thalimenos fits a bit in the middle. That seemed to be their thinking.
Yeah,
and if you're doing that, I mean, I suspect that if they'd just done the analysis you just outlined, we'd be here on a challenge that says you need to approach Thalimenos in a different way.
Well, that's why I said a moment ago, Mr. James, that we may need your assistance on how we should deal with Thalimenos and whether it is exactly the same analysis as indirect discrimination. Because for the reasons I just outlined, I'm not sure it is exactly the same.
No, my Lord, well, may I think about that over the short adjournment? But I'm assuming for this purpose that in principle, the halfway house Thalimenos does require you to focus on the reasons for not treating the group in question more favourably, as it were the flip side or the thing closely related to a direct discrimination analysis where you focus on the difference of treatment. That's, I think, in fairness to the divisional court, what their reasoning looked like. I think they say at one point earlier on in the passages we've already looked at, Thalimenos is somewhere between the two and feels a bit more like direct discrimination in terms of what you're having to justify, namely the difference in treatment or the non-treatment of these as favourable. And obviously if you're in that territory, assessing what the alternatives may be, despite the holding of the serious religious beliefs, and I'm not sure I don't necessarily agree with my Lord or accept that this smells like dictating what people's philosophical convictions should be. And the Strasbourg case law, as I say, we went to it under A2B1, is redolent with these difficult questions about how much education has to, as it were, comply with the wishes or demands, however sincere, however deeply held, of particular parents or groups in this sphere. Or is it just about the education in a pluralist, non-denominational way, and then everything else is for the parents as long as you don't indoctrinate? Those sort of issues have frequently come up in Strasbourg. So the pointing to the existence of a pluralistic, non-denominational state system is not in any way, shape or form intended to be, or needs to be in this set of submissions, a criticism of or a denial of the sincerity or depth of those beliefs. It's simply pointing to the fact that the education system is set up to try to cater for those all faiths and none, as it's put in paragraph 8.
Sorry, all faiths
all faiths and none.
Yes, yes.
And of course it applies to religion, it applies to deeply held philosophical beliefs which are treated in the same way, and so on. So it's perhaps unsurprising that the state system is deliberately pluralist.
Maybe continue at 2 o'clock, Sir James.
Court rise of April.